going to speak to you about Article 21. I shall begin my lecture by firstly highlighting the origin of Article 21, followed by its interpretation, and lastly, I shall be discussing the important precedents and the latest case laws of the Supreme Court. With this, let me begin my lecture. Article 21 seeks to enshrine protection to everyone within the geographical terrains of India and ensure that they have a quality life and their personal liberty is protected. However, at the same time, it also chooses to ensure that there is curtailment of this liberty and life through procedure established by law. When the makers of the Constitution were debating about incorporating Article 21, they ensured that they rely on a number of documents which existed at that time. This included the Magna Carta, which was the Great Charter, Article 40, Subclause 4 of the Constitution of Ireland, 1937, Fifth Amendment to the Constitution of United States of America, Article 31 of the Constitution of Japan, 1946. It is important to note that the Legislative Assembly it is important to note that the Constitutional Assembly at the time of debate with respect to Article 21 wanted to compare the various. Okay, I'm just getting very nervous about this one.
Just resume from this part.
Where should I resume from?
This page. Okay. Start explaining.
At the time of the incorporation of Article 21, the makers of the Constitution wanted to compare the various legislative documents and the constitutions available to them and ensure that the best practices are adopted in India. Therefore, reliance was placed on the Magna Carta, the Great Charter, Article 40, Subclause 4 of the Constitution of Ireland, 1937, the Fifth Amendment to the Constitution of United States of America, and Article 31 of the Constitution of Japan, 1946. At the time of the debate, the Constituent Assembly had two views: whether to incorporate due process as witnessed in Article 5 of the Constitution of America, or whether to establish procedure established by law as envisaged in the Japanese Constitution. Eventually, it was decided that at the nascent stage, it is important that there is a clear distinction between the judiciary, the legislative, and the executive. Therefore, it was suggested by Dr. B.R. Ambedkar that instead of adopting due process, the phrase procedure established by law would be appropriate in the Indian context, whereby the judiciary would not be given the additional power to be able to interfere in the legislature. The term procedure established by law basically means that whenever the legislative or a statute decides how the life of an individual or the personal liberty of an individual is to be curtailed, there shall be no judicial interference in that particular procedure. We can see this particular interpretation in the recent judgments of the Supreme Court, and how when we trace the history of judgments, we see that there has been a fundamental difference in the way Article 21 was interpreted initially and the way it is interpreted now. In 1950, we see the famous case of A.K. Gopalan versus State of Madras, whereby the appellant chose to challenge his detention under the Preventive Detention Act, and it was interpreted that the legislature had discussed the process as to how detention was to take place. And though there was no hearing given to the appellant regarding his detention, it was held that the petitioner had been detained under the Preventive Detention Act as per the letter of the law. And at this point of time, there was no scope for the judiciary to interfere in the detention of the appellant. However, in the landmark case of Maneka Gandhi versus Union of India, 1978, the scope of Article 21 expanded enormously. It was held that procedure established by law has to be just, fair, and reasonable. In the present case, Section 10(3) subclause C of the Passports Act was challenged as to be held ultra vires to the Constitution. It was held that without offering any reasonable explanation, the passport of the petitioner was denied to the petitioner, and therefore it was held that without giving an opportunity for the petitioner to be heard, her right to travel abroad could not be curtailed in an arbitrary, unjust manner. Therefore, now we were given the doctrine that whenever there is a law that lays down how one's life and liberty has to be curtailed, it must be ensured the procedure is just, fair, and reasonable. This opened the gates for a plethora of judgments, which further expanded the scope of what constitutes right to life. And gradually, we see that right to life means the way one conducts their life. Therefore, we have the six-judge bench judgment of Khadak Singh versus State of Uttar Pradesh, which held that right to life includes the right to live with human dignity. Though privacy is not a constitutional right, it was held that there has to be reasonable restrictions on how the police also interferes with a person who has been granted bail, and at the same time surveillance has to be conducted by the police. In this particular case, the UP Police Act was challenged successfully, and it was held that the police cannot go to the detinue's house in the middle of the night, and surveillance conducted by the police has to be reasonable. Vishakha versus State of Rajasthan saw the fact that Article 21 also enshrines gender parity and also ensures that the principles of international law, CEDAW, that is Convention Against Atrocities on Women, can be enforced in India as well. In this particular case, the genesis of the case traces back to the brutal gang rape of a social worker in Rajasthan that led to ensure that there has to be safety of women, working women in the workplaces, and it also put an onus on the employers to make sure that there are anti-sexual harassment guidelines within the workplace. And at the same time, employees were given a complaint mechanism. It is this landmark judgment which sees the foundation of the anti-sexual harassment law that exists in and was founded in 2013. Bodhisattva Gautam versus Shubhra Chakravarti ensures that the act of committing rape is not just a physical brutality that a person endures, but the survivor has to be rehabilitated. Under Section 357 and 357A of the Code of Criminal Procedure, one is entitled to compensation by the state. However, in this judgment, it was noted that victim compensation shall be determined by the court, who has the power to try the case at the interim stage as well. Because the act of rape leads to severe impact on one's emotional, psychological, and mental well-being, and it is important to provide financial aid to a victim, or rather a survivor, to ensure that she has a quality of life. With this, we must also go into the analysis of the negatives of Article 21 in terms of whether it constitutes the right to die. In Gyankaur versus State of Punjab, another constitutional bench judgment, which led to the overruling of the 94 judgment of P. Rathiram versus Union of India, it was held that committing suicide is contrary to the tenets of right to life. The Gyankaur judgment sought to challenge the constitutional validity of Section 306 and 309 of the Indian Penal Code, which deals with abetment to suicide and attempt to commit suicide, respectively. These offences were held to be within the constitutional ambit, and it was held that committing suicide is contrary to the tenets of right to life. Therefore, the position of the judiciary changed. In P. Rathiram, it was held that right to life constitutes the right to die. However, now the position was that right to life does not constitute the right to die. Furthermore, this doctrine evolved in Aruna Shanbhag versus Union of India in 2011, which recognized the principle of passive euthanasia. This was a case where a nurse of the KEM hospital was brutally raped, leading to her being in a vegetative state, and she was on life support. An application was moved for removal of life support, and it was held that she did not have a life of dignity when she was being subjected to life support, and it led to trauma for the people around her as well. Therefore, this was a case when passive euthanasia was recognized by the Supreme Court of India, whereby the right to life included a right to die with dignity. This doctrine further developed in the recent case of 2018, where Common Cause, an NGO, moved for the recognition of the right to living will. Now, as per this particular case, the right to die with dignity was further enhanced to include the right of self-determination and the right to bodily integrity. In this particular case, the unanimous decision of the Constitutional Bench recognized that when one has led a fulfilling life, then a person cannot be then the person's right cannot be taken away to decide how that person shall die when it comes to determining their medical course of action that they can be adopted. While determining the medical course of action for a person who is in the vegetative state, it was held in the Aruna Shanbhag case that a team of medical experts will be constituted and an application can be moved before the High Court of the particular state to ensure that that particular application is considered along with the opinions of the expert, and if the court is satisfied that there is no life left in the individual and the person is just in the vegetative state, then life support can be removed. Similarly, in Common Cause, this was enhanced one step ahead, and it was held that the person, whenever he is capable of making decisions regarding how he shall be treated when it comes to medical treatment, such decisions will hold value, and that person's decision regarding the way his life should end, whether he should be put on life support or not, will be of paramount importance. Hence, now the current stance with respect to right to die includes the right to die with dignity, and the concept of living will has been recognized in India, as well as the concept of passive euthanasia has been recognized in India to the extent that when a person is brain dead or when he is in passive vegetative state, which means that the only the brain stem is functioning and the cortex has died, then that person can be removed from life support. Now, who determines when the life support can be removed? It would be either the next of kin or friends if there is no immediate relative in the form of parents or spouse available. And it will, and as can be witnessed in Common Cause versus Union of India, if the person himself or herself has determined the medical course of action that needs to be taken, that will be given primary importance. Next, I'd like to discuss death penalty within the ambit of Article 21. In the case of Jagmohan Singh versus State of Uttar Pradesh, the constitutional validity of death penalty was discussed, and it was decided that since the judiciary has the discretion regarding what kind of sentence that one needs to impose, therefore the constitutional validity of death penalty was upheld. In Bachchan Singh versus State of Punjab, the doctrine of rarest of the rare cases was enunciated by the Honorable Supreme Court, and it was held that when the judiciary decides that one's life needs to be taken, it is the highest form of punishment that can be given to an individual. And while coming to this decision, the judiciary must ensure that the mitigating and aggravating circumstances are taken into consideration. In the case of Dina versus Union of India, this was one of the first cases which saw that application of the rarest of rare case phenomena being applied to the case. In this particular case, the appellant was out on bail while undergoing a murder trial, and during the course of the trial, he committed another offense of murder. It was held by the Supreme Court that there were no mitigating circumstances to ensure that the person is not given the death sentence and his death sentence is commuted to life imprisonment. Therefore, in such a case, we see an analysis of the mitigating and aggravating factors that must be taken into consideration while determining whether a particular case is suitable for death penalty or a lesser sentence can be awarded by the judiciary. Furthermore, it must be ensured that reasons for recording the sentence are made public and are recorded in the judgment of sentencing. Lastly, I would like to conclude by going about some important recent judgments which see how Article 21 brings about a change in our daily lives. In the case of K.S. Puttaswamy versus Union of India, right to privacy was recognized as a fundamental right by a 9-judge constitutional bench in Supreme Court of India. Right to privacy is not just a fundamental right, but however, it is not an absolute right and it is subject to reasonable restrictions. These reasonable restrictions come from various other legislations, be it in the form of national security, be it for the purposes of surveillance and ensuring that an individual does not become a threat to the society. At the same time, right to privacy led to decriminalization of homosexuality in the Navdeep Singh Johar versus Union of India case, whereby Section 377 of the Indian Penal Code was decriminalized to the extent that two individuals who were consenting adults engaging in practices of homosexuality, such acts would be legalized and or rather such acts would not be treated as a criminal offense. Right to privacy affects various aspects of our life, as can be observed with respect to data security in terms of Aadhaar, wherein it was held that we are giving the bare minimal biometric data, and therefore it was in consonance with the policy of privacy as envisaged in the judgment of K.S. Puttaswamy versus Union of India. Thank you.